Hi again, it's Deb James, the Wellness RN for you, and I'm here with some more practical dementia care tips. In this video, we're going to talk about having uncomfortable conversations. And the uncomfortable conversation we're going to talk about this time is who's in charge? This is something that you need to determine before your loved one advances in their dementia, because you want to get things in writing. You want to have legal documents that express what that individual wants before they're unable to adequately express that. So there are different types of powers of attorney. You can have a power of attorney for finances. You can have a power of attorney for medical situations. And you can have a power of attorney that is a durable power of attorney that covers everything. That is not usually recommended, just because it can lead to some issues with someone not doing what they should be doing and no one else being able to prevent that, unfortunately. For the power of attorney for finances and the power of attorney for medical situations, they do not have to be the same person. And oftentimes they are not the same person for many reasons. Some of those reasons are that there is someone in the family or there is a friend who is more well versed in medical issues. And so they would have a better sense of what things need to be taken care of and how to best care for that loved one with dementia. Financial power of attorney, that person would be responsible for making sure all bills are paid, making sure that money is being used judiciously, that they are using the loved one's funds for the loved one. Now, I got into a special situation because my father was a veteran and he had veterans benefits. Some of those benefits passed on to my mother. Unfortunately, because of her dementia diagnosis, someone had to become a fiduciary for those benefits with the VA. And that turned out to be me, which made sense because I was paying all the bills anyway. I was making sure all the bills were paid, taxes paid, utilities, all that, medical expenses. I was making sure that they were paid. So I took on that role of fiduciary. Now, if you're in a situation where you're a fiduciary, that means you have to keep very detailed records. You have to have detailed records of when money is deposited, when it is used, what it is used for. Because typically every year or every 2 years, you will be audited by whoever set up the fiduciary. So you want to make sure that you have all of those records in place. You know where they are. They're clear, forthright, everything's by the book, literally. And that way you can show that the money is being used for the loved one and that nothing unacceptable is happening, to put it bluntly, but to put it nicely. So that would be power of attorney for financial matters. Now, for medical matters, that can be another person. Again, that person hopefully has a medical background, has some type of understanding of how things work on a medical, physiological sense. And they would kind of act as a go-between between the loved one and whatever medical services they're being provided. So if they have doctor's appointments, they would be involved in that, possibly to the point where they would go with the loved one to make sure that everything is understood, that all the information is accurate, that they're getting, because sometimes your loved one might not get it all completely. Sometimes, there's confusion. There's confusion even for people without dementia. So, you want to make sure that that's squared away. And those are two very uncomfortable conversations to have. But you need to have them. You really do. Because you don't want to wait until the person is advanced in their dementia in such a way that then you might have to have a third party come in and make decisions. And naturally, you want to make decisions for your loved one. You are the one that's going to be taking care of them. So in order to do that, you have to make sure that you have powers of attorney in place. Now, don't put them together without your loved one's involvement. That's a big no-no. That's a big no-no. They need to be involved. They can say who they want to have access to their medical records. They can say who they want to have access to their finances. They can determine that. And if it's a bad choice, you'll have to deal with it. You can't just arbitrarily change it because you think your loved one made a bad choice. Because these powers of attorneys have to be signed and notarized. So some of these have to be done by an attorney. They don't always, but whatever the case, they need to be notarized, which means that your loved one has to have a third party document that the signature on the paperwork is the loved one's signature and that they are doing it freely without any coercement. So, two conversations that need to be had. They're difficult, but again, approach it with understanding. Approach it from the standpoint of making sure that your loved one knows that you're trying to take care of them. You're trying to do the best for them. You're not trying to cheat them out of their money. You're not trying to keep them from having any type of medical care. You are wanting to do the best for them with their input. That's the key. Okay? In case you're available, starting February 4th, I will be doing a live stream of my Practical Dementia Care course. So those of you who are interested, let me know. Check out my website, angelictouchhealthandwellness.net, or you can email me, deb.wellnessrnforyou@gmail.com. I will let you know when the link is sent out. I will make sure that you get one. And this will be every Thursday, starting on the 4th, for 6 weeks. So Thursdays at 3 p.m. Eastern Time, I will be going live to provide education. And if you're not available, there will be a recording that will be posted afterwards. So again, looking forward to that. Looking forward to seeing you, hopefully. And until next time, have a wonderful day. Bye.